Rae Kaplan. You're the best in the business when it comes to helping people with student loans. So
Absolutely.
why don't you explain to the audience who isn't familiar with what you do,
In terms of what we do, so we have a pretty large bankruptcy practice, and I've been practicing since 2001 in bankruptcy law. And we started practicing non-bankruptcy student loan law in 2015, essentially because we wanted to. Well, I really started to look into it because I wanted to find out what I could do with my own student loans. And also I realized that there was a problem in terms of how I could advise my clients on what to do with their student loans. Everybody kind of seemed to be of the opinion, all of the experts and everything, that there was really nothing you could do about student loans. It was very rare that you could do anything to get rid of them or to reduce the payments. And when I started to really dig into it, I realized that that's not the case.
Talk a little bit about student loans in bankruptcy, right? Because this is where that's kind of what my background is helping people with bankruptcy and trying. And I know that in bankruptcy, difficult or not or almost impossible to get rid of them.
Right, exactly. So in bankruptcy law, as you said, it's very difficult to get rid of private student loans or any student loans, federal or private student loans. That used to not be the case. Then they changed the law in 2005, and it's much more difficult to discharge, meaning to get rid of student loans in bankruptcy. You essentially have to show that you are there's the Bruner test where basically you'd be paralyzed from the waist down or something, that you would never ever be able to repay them. And it's a very high bar, and it's very expensive to litigate that issue. Once we started to look into, okay, what are the options with student loans, and is there anything other than trying to file an adversary in a bankruptcy to potentially get rid of them, which is going to cost the client a lot of money, and then there's the risk that they're not going to rise to that level, they're not going to meet the standard, they're not going to be able to get the loans discharged, because it's almost impossible for federal student loans, and for private student loans, it's also very difficult. Although the law is changing in some districts now. So
I have seen
the
that.
Ninth, there's some case law now where basically, and we tried this argument with one of our local judges, and she wasn't buying it, but I won't mention her name, but essentially in these other districts, basically, if you make the argument that a lot of these private student loans don't meet the statutory definition of a student loan, then it's not a student loan, but rather it's a regular old contractual debt, just like Visa or MasterCard, and it should be dischargeable. And the statute actually goes to a lot of trouble to define and to determine what is a private student loan, but it seems that Illinois courts don't really want to necessarily go to all the trouble into determining whether or not these particular loans qualify as student loans. It's rather complicated.
Let me interrupt you again.
There was great information.
That's what I'm saying. And I'm going to tell you, because the only time you can get a student loan is if you have a balance with your college and you haven't gotten a loan out. Now that is not a student loan. It's what you owe the college. That is dischargeable. So I've helped a lot of people.
That's tuition.
Yes, tuition. So, but people get that confused because that can't be dischargeable. So I've just had a case where the school wouldn't give somebody wouldn't let them back into school because they owed money. Yeah. And I tell them, no, this was been discharged in bankruptcy, and I had to go through their their lawyers and all that. But it's pretty straightforward. But again, a lot of people still get that confused.